Good afternoon, everyone. Give me just a moment, make sure we're all good to go. For those on camera, can you put a thumbs up if you can hear me okay? Perfect. All right, great. Good afternoon, everyone. My name is Wesley Stefanick, and I am the Chief Executive Officer of the Delaware Association of Realtors. On behalf of our team, I want to thank you for taking the time to join today's Zoom session as we explore an important new development in Delaware real estate, the introduction of transfer and death deeds, which are now officially permitted in our state. This is a significant topic for realtors and consumers alike, as it impacts estate planning, property transfers, and the future of how Delawareans manage real estate ownership. We're excited to shed some light on what this change means and how it will affect your work and your clients. I'm especially pleased to welcome two outstanding guests who bring deep experience, expertise, and firsthand knowledge to today's discussion. First, we have Andy Taylor, the Delaware Association of Realtors' longtime legal counsel, who has guided our members through countless legislative and legal issues over the years. And also joining us, we're privileged to have the Honorable Gene Thornton, Recorder of Deeds for Kent County, who plays a critical role in the implementation and administration of these new deeds, and a longtime proponent of transfer and death deeds, and a good friend of our association, if I might say.
Thank you.
Before we get started, just a quick housekeeping note. This session is being recorded, and a link to the recording will be available on our website, delawarerealtor.com. You'll also receive it in tomorrow's Fast Facts email, so you can rewatch it and share with colleagues as you see appropriate. Once both Andy and Gene have finished their presentations, we'll open the floor for questions and discussion. Please feel free to type your questions in the chat box at any time. Please direct them directly to me, Wesley Stefanick. You can find me in the chat. I believe there's two options. Don't send it to the one that says Delaware Association of Realtors. Again, thank you for being here and for your continued engagement and staying informed and proactive on issues that shape Delaware real estate. With that, I'll turn it over to Andy to get started.
Thank you very much, Wes. Appreciate it very much. And Recorder Thornton, thank you so much for joining us today. Really appreciate it to bring your perspective and expertise to all this. So
my pleasure.
Good. And I have a PowerPoint here that to cover just some of the basics. So Wes is going to tee that up for me to be able to do that.
Hi. We are recording the transfer on death deeds in my office now. And Andy will cover why that is so. I just want you to know that we have a website. And on that website, I've curated quite a bit of information about the transfer on death deeds that you might be interested in. The same with property fraud. It's quite in-depth, questions and answers. I've got news articles from around the country, links to the law, and of course, for the transfer on death deed, I have the form, the revocation form, and the transfer on death deed itself. And all recorders are using the same form. So no matter if you download it from my website or the other county's websites, we'll all accept that one document, which is first, I hope, among the recorders to start sharing things and making it easier for our constituents.
Good. Thanks for that introduction, Gene. Appreciate it very much. So I believe now you can see my PowerPoint.
Yep.
All right. So there we go. So here, I'm going to cover just some of the basics with you here as part of this session. So here we go. So just the basics here for you. These are summary slides for me. It's not a substitute for legal advice, and it's only a summary of some of the sections of the law relevant to real estate agents and handling transactions in Delaware. It is not a comprehensive summary of all the sections of the law. So transfer on death deeds might also be referred to as a TOD. You know, in the real estate world, we have a lot of alphabet soup, so there you go. It came from a group called the Uniform Law Commissioners. The full title is Uniform Real Property Transfer on Death Act. 19 states have adopted this, plus DC and the U.S. Virgin Island. It allows for passing real property without going through the probate process. It's similar to life insurance that has named beneficiaries, or brokerage accounts for investments with beneficiaries named on that, or pay on death bank accounts. And this sample uniform act was customized for Delaware in large part through Recorder Thornton's efforts on that. I think you had a key role in the insurance provisions of it and some of the probate provisions of it. And that took what, a couple of years or so, didn't it? So,
6 months.
okay. And I know there have been various times, various drafts of it floated around and bills that were looked at over a couple of years. So what passed is shown on the screen of HB 147, a House substitute for that with the House amendment. And although the law includes sample forms, and as Recorder Thornton has mentioned, are available on the Recorder Deeds websites, it really should be considered as part of the entire estate planning for the individual. It's good in some instances, not all cases. So it really, if a member of the public is asking you, do you think I should do a TOD for my property? Suggest that they talk with a lawyer about that. It really should be considered as part of their overall estate planning to make sure it's really appropriate in that circumstance. But the basics here, just the bare bone basics of a TOD, an individual may transfer property to one or more beneficiaries effective at the transferor's death by the transfer on death deed. And it can be recorded now. The law specifically says it's only effective for someone dying after December 5th. That's the effective date of this. It is revocable even if the TOD or another instrument contains a contrary provision. So, for example, maybe you're going to list a property for sale. They mentioned, I did something called a TOD some years ago. I'm not quite sure. Is that still in effect, or what do I need to do about that? I'll talk a little more about that in a second, but they might say, I said it was going to go to my daughter, but now I need to sell the property. Is it okay for me to go ahead? You'll see a few more slides hang in there, how easy that is to deal with. And it is revocable even if the TOD or another instrument contains a contrary provision. So if they say, I promised my daughter she was going to get it, I even put that in writing to her, that does not bind that property owner. They can go ahead with listing and selling the property, even if they had something else in writing saying they wouldn't revoke that TOD. The law specifically says it's revocable. The mental capacity for somebody to do a TOD is the same as the capacity required to make a will, and notification of the beneficiaries is optional. So hopefully you hung in with us this long with your attention span. Here's, I think, a real important slide for you, listing a property that's currently titled with the TOD. You'll be surprised how simple it is and how little effect it has on your transaction. You do not need to contact the beneficiaries named in the TOD unless the owner wants to. You do not need the consent of the beneficiaries. You do not need any signatures of the beneficiaries. It's not necessary to record a revocation of the TOD before your listing. The new deed to the buyer as part of settlement acts as a revocation of the TOD. Or maybe the settlement lawyer might choose to have the owner sign a revocation to be recorded just before the deed of the buyer, even though that's not required. That'll be up to the settlement lawyer how they want to handle all that. So you can see there's really no change in your listing process just because it's currently titled with a TOD in effect. Now, the requirements for a TOD, and this is where, again, Delaware's law was customized a little bit to have some additional protections. It needs obviously to be signed by the transferor or the grantor on the deed. Must include the same essentials of a regular deed in Delaware. Needs to be witnessed by two individuals. This is one of our customizations here, that at least one of whom must not be related to, must not be a beneficiary under the TOD. So at least there's one, hopefully truly independent type witness. Maybe if they felt this person was being somehow pressured to do a TOD, they might say, you sure you want to do this? Or could we talk for a second? Just something like that. All signatures must be notarized and state that the transfer to the designated beneficiary is to occur at the beneficiary's death, be recorded before the transferor's death in the recorder deeds office where the property is located. That's actually something that's a little bit different than a regular deed. Suppose last week I had signed a deed to you, and then the day after that I died before it was recorded, but I had signed the deed, I delivered it to you, it just had not been recorded yet. that delivery of the deed constituted the transfer of title to you, even though I died before it was recorded. But with a Todd deed, it must be recorded prior to the transferor's death. However, another difference from a regular deed is notice to the grantee, to the beneficiary, is not required. Delivery or acceptance by the beneficiary is not required. There does not need to be any additional consideration for that deed. But note, because you might think, well, gee, there's a Todd deed. Suppose the person dies and the beneficiary says, well, I didn't know about that and I don't want that property. What do I do? They can do a disclaimer. So that's specifically in the law. They can do a disclaimer, gets put in with the records to show that that beneficiary is not accepting what the Todd was trying to transfer to them. What if somebody changes their mind? They've executed a Todd, it's been recorded. Can they revoke that? Yes. There are different methods for revoking it. A new Todd could be done that revokes the prior Todd or is inconsistent with it, so it changes the beneficiaries. There could be a revocation instrument recorded. Ms. Thornton mentioned that revocation form is also available on the Recorder Deeds websites. Or there could be a deed made and recorded while the owner is alive that includes the revocation as part of that deed. You cannot revoke a Todd by destroying it. So somebody has executed a Todd. It's been recorded at Ms. Thornton's office. It's been returned to the appropriate party on that. And they decide, I'm so mad at that. I don't want them to get this property anymore. I'm tearing this up. That's not effective to revoke that Todd. Unlike a will, if there's one original of a will, the person hasn't died yet. If they destroy that will, that is an effective way to revoke a will, but not with a Todd. They would need to take one of these steps in order to revoke that. With tenants in common or joint owners, there's specific sections in the law dealing with that. There's also sections dealing with revocation by co-owners. Not going to go through all that right now. So during the owner's lifetime, what's the effect of the Todd? Not much. The owner can still convey without consent to the beneficiaries, can still, they can make a will, but a provision in the will that might be contrary to the Todd will control. Because the will does not act as a revocation of the Todd. The owner can still mortgage or encumber the property without the beneficiary signing the mortgage documents or even knowing about it. Does not affect the rights of creditors of the owner. The beneficiary does not have any rights in the property. Creditors of the beneficiaries do not have any lien or rights in the property. So you can see really the effect of the Todd is everything takes effect when the person dies. That's the whole point of it. The process after death, the record of death is made through the probate process, listing the property on the inventory, or if probate is otherwise required. Just because there is a Todd doesn't mean there has to be the probate process. If there's no other need to go through the probate process, then the Todd itself does not trigger the probate process. There's processes within the law for filing the death certificate along with the form at the Register of Wills if probate's not otherwise required in order to document the date of death. The tax assessment office is notified. Now, there are claims against the estate. If there were creditors who filed claims against the estate that can attach to the Todd property, just like current probate process allows for an 8-month claim period after date of death. The sample forms are available within the law and on the Recorder Deeds websites. There are also very good FAQs within the law itself, and there are good provisions. I mentioned that Recorder Thornton worked on realizing we needed to make sure that insurance remained in effect for a certain period of time after the Todd took effect. And so as a gross overgeneralization of what these sections say, it basically allows for the insurance to continue up to 60 days. But you take a look at the law for all those requirements with that. Recording of a Todd is exempt from realty transfer tax. So no state transfer tax, no local transfer tax. They don't even need the transfer tax forms or the state of Delaware estimated income tax form to go along with that, Todd. It's intended to be a simple recording process, and maybe Recorder Thornton will talk a little bit more about that. So that's my very simplification that I have for you about the provisions that I see from the transfer on death law that we have in Delaware now as it relates to your practice of real estate, which I think you can see it doesn't change too much. And just be aware, I know you're not practicing law, so if somebody asks you, gee, should I do it, Todd? You encourage them, talk with a lawyer. It really should be thought about in context of their overall estate planning. So there's some basics for you. We'll make these slides available to you as well, if that helps you to review it. And I put the sections in there from the law. We can post the bill itself on the website as well, so that you can refer back to it and study it more if you'd like. And if you come up with some additional wrinkles or things with this in transactions, by all means, give me a call, send me an email, something like that, that I can hear about how it's working out in the field, and we can all share our experiences there. And don't worry, Wes, I don't charge DAR for those kind of communications. Okay. Thanks, folks. And I'll turn it over right now to Recorder Thornton. And thank you again so much for your efforts and fine work on making this a reality in Delaware. So I'll let you go ahead and take it from there.
It was a little bit of a fight to get it through. But I think what people need to understand is the Todd is a deed. It's not a will. And where you get into trouble is when you think it is a will. For example, on the Todd, you will see primary beneficiaries and you'll see alternate beneficiaries. Well, you're thinking will, so you're thinking if you have three people, 3 children, one of them dies, they have 2 children. Now you're thinking, okay, that alternate beneficiary is those grandchildren and they're going to inherit. No, that's not the case. What would happen is that if the first person dies, the surviving 2 siblings will inherit 50-50 and the grandchildren get nothing. Unless the person, the grantor, remembers, hey, I have a Todd, and then I want to add the grandchildren in, then they can revoke by making a second Todd and overriding, in other words, or it doesn't override it, they both stay there in the chain of title, but that the only way you can really accommodate for those kids would be to redo the Todd, because otherwise every single primary must die before any alternates inherit. So that's you just can't think of it as being a will. It's not, it's a deed. And just like a deed, you can sell your property to the dog walker if you want to.
Right.
It doesn't have to be to whoever your heir is. Well, the Todd is like a deed. So you can give your property to the dog walker as long as you are of sound mind. And you've got 2 witnesses that will say you're of sound mind and memory, and you're not under duress by anyone, to include one of them, and a notary to sign, to review, certify everybody's signatures. You can go ahead and leave that property to the dog walker, and your heirs have nothing to say about it. Well, they may say something, but they won't prevail. So, and that is why when we take a look at the after someone dies, you get the Register of Wills has got to get the beneficiary gets a copy of the death certificate, takes to the Register of Wills. Well, in the office where they had to get that, it says only relatives can have it, right? So it doesn't say the dog walker can have it. So the Todd law says whoever is the beneficiary may go to the vital statistics and get that document to take to the Register of Wills. So there's a lot of little, things like that. We just have to remember it's a deed, and you can leave your property to anybody, and it doesn't have to be relatives. And I recommend that people who use the Todd also use our property fraud alert program, because the kids, the heirs, can register for the parents, and then when the parents change anything like the Todd, then if they were heirs before, at least they'll know about it. So if there is hanky-panky, they can look into it and the parents will still be alive. And so, a determination can be made if they're in sound mind or not. So anyway, I'm happy to record these deeds now. We've had 45 recorded so far, and people love them. And before I supported this bill, I talked to a dozen of the 19 other places where the uniform law is in effect. I talked to clerks and probate offices. I talked to owners of title companies. Didn't talk to any real estate agents, but I'm pretty sure they were happy about it. And there really aren't issues with it. I mean, in Delaware, we're all spun up about it because it's so new. But, in Chicago, Cook County, Illinois, they've let 30,000, they've recorded 30,000 Todds in the last decade. And they're not experiencing problems. And when they did a study of the urban area, they found out that the Todds actually create generational wealth because they eliminate the tangled titles. And I'm sure that would be very happy to you realtors to know that if people use a Todd, I mean, these are people who would ordinarily not see an attorney. They're people who don't have the money, don't trust the attorneys, don't work hours the attorneys work, whatever the reason may be. This does give them a fighting chance to leave their property to who they want and avoid the time delays of probate and the expense of some of the other things. Now, I was talking about expense. My Todd is $88 for the first five pages. And for every page after that, it's $10 per page after. And the reason I set that is because so far, when I've recorded, the mean, the mode, and the median number of pages has been 4, not 5, 4. But if the legal description is long, that puts it into 5, and that makes it $98, and that's just really expensive. So I got Levy Court to redo my fee ordinance. So it's $88 to record it. First 5 pages, that means the 5th page, if we need it, is free. So I'm happy about that because the people who are the primary target for this law are people who use money and money orders, and they need to know how much. They can't write a check when they don't have checkbooks. They can't write a check and find out. So I'm pleased to have done that as well. And the other thing I've done in Kent County, and I've suggested it to the others. I'm not sure if they've done it yet, or they may be waiting to do it. But on my list of documents, when you put the person's name in, you're going to see the list of documents which says deed, lien, whatever. Now you'll see Todd, Todd, or R Todd. And that means Todd and revocation. And so that means, too, when they go to an attorney and they want to make a will, the attorney can look it up real quickly and say, well, there's a Todd here, because if they make a will and it's different, the Todd will prevail. So I did that change with my software vendor as well.
No, that's very good. I might just mention the tangled deeds. You might not have heard that term before, but let's say someone dies without a will, and the process is not done through the Register of Wills office for that, but through the intestacy. Maybe it would have gone to 3 people, and then 2 of those people die, and they don't have a will or settle the estate either. And before you know it, in order to clear title of that property, you would have had to find 15 people, 18 people, maybe across the country, trying to track down and do some genealogy research, et cetera, and all sorts of paperwork to try to clear up the title. But what Recorder Thornton has mentioned is that person, when they own it, if they thought, oh, gee, now I can do a Todd, I can say that it's going to go to my 2 children, or it's going to say it's going to go to my niece and nephew because I don't have children. And then you're not going to end up in that tangled title type situation. So,
and we can't record it if it has a tangled title. It has to be clear title. So this is why I'm looking into trying to establish a fund maybe to help defray some of those costs for those low income people through one of several nonprofits that exist already for that purpose.
Oh, that's interesting.
So I'm looking into that.
Wes, do we have any questions at this point?
We do have questions.
Go right ahead.
All right, I'm going to jump right into them. Just so everyone is aware, Zoom kind of changed the way questions come in, so it's a little more complicated. So I'll try to get as many as I can here. First and foremost, Recorder Thornton, you mentioned a website at the start. Could you just repeat your website from earlier?
Sure. Well, it's the Kent County website, but it's really hard to negotiate that website. But if you just Google Kent County transfer on death deeds, that should take you right to the site, and you'll see a picture of me with. When I get a better picture, I will substitute that picture. But for now, just memorize what I'm wearing now, because it's the same thing I had on that day. And I'll take you through the whole thing. I've got links to what is a tangled title, what is heirs property. I've got some discussion from estate attorneys in the Delta, the Mississippi Delta, where there's a lot of low-income people that have used the TOD very successfully. I've got a study from Cook County, Illinois, that 30,001 that I mentioned. You can read that and see how tangled titles have helped in the urban center of Chicago, to the point where they go out 3 times a week to try and talk to people about taking TODs. Because remember now, they're not trying to talk people into taking a TOD instead of a will. These are people that won't take a will at all. So this is a form of estate planning for them that they might not otherwise have. Of course, if you can afford an attorney, you certainly should have an attorney. And as it turns out, according to the Uniform Law Commission, those places where they have TODs, some estate attorneys were afraid, maybe they objected to it. But it turns out that people that have relationships with an attorney continue to have relationships with an attorney, and those that don't at least now have a fighting chance. And for you realtors, you'll be happy to know that once the people go to the Register of Wills office, and they can take that affidavit, they can take that TOD, they can come to your office, and you can start to sell that property. Even though 8 months was mentioned, that's in rare situations. The property transfers instantly upon the death of the person who granted it. And when I say instantly upon it, they also have to have recorded it. So it can't be found like a will. You can't find a TOD lying around in the personal effects. You can't, if they've mailed it to me and I haven't recorded it, it's not in effect. If it's in my office and it gets there after recording hours on a Friday and they die on Sunday, it's not in effect. They have to record it in my office. But, I put the day and time and minute. So as long as they die before those times, after the 4th, on or after the 4th of December, right, the TOD will be in effect.
All right. Do TODs work well for unmarried couples who bought property individually but want to leave that property to their partner without either probate or trust, or a trust?
Could be done that way. So there's a unmarried couple. I gathered from the question, there's only one of them on the deed, and they want to make sure at their death that it would be owned by the other person. They could do a TOD and list their partner as being the beneficiary. That could accomplish that very nicely in that situation.
Is this for primary resident only, or for investment or second home properties?
I'll take that one.
Go ahead.
The TOD is between living persons in Delaware. Some states, that's not the case, but in Delaware, it's between living persons. So you can't leave it to a corporation, a nonprofit, or even a trust. Though you might be able to leave it to a trustee, but not to the trust. So it has to be between living persons, and that's why it's important if somebody dies, if somebody that you've benefited with the TOD dies, you have to consider what the ramifications of that are and possibly do a revocation or a second TOD to change the beneficiaries.
If a TOD is filed prior to a will being created and the will names a different beneficiary to the property, does the will override based on date of filing notarized execution of the will?
Nope.
No.
That was unison there. You never see a politician and a lawyer agree on anything, but yeah, we said it simultaneously.
Hold on. I don't put you in the category of politician.
Thank you. I
put you in the
elected
category
official.
Public servant.
Thank you. I appreciate it.
You've done a lot of good things for the public through your
Well,
office, so we thank you for that.
Well, thank you. But the answer is no.
This might be similar This is for you guys to decide. If an owner executes a Todd early on in his life and then forgets totally that he executed the Todd, he passes, and his will is in conflict with the Todd, what happens?
Todd controls. So hopefully whoever helped with drafting the will, as Recorder Thornton mentioned, thought to look at the recorder deed site, see if there's a Todd already recorded, and then do a revocation of that as part of the estate planning process.
So the beneficiary is not responsible for any state taxes or transfer tax when it transfers. Is that correct?
Yes, but if they sell it, then they will be. And that's the other good thing. A lot of people, they try and make it easy for the kids. So, I mean, we're talking about this particular income level of people. They'll just add their children to the deed instead of using a Todd because they didn't have choice of using the Todd before. And that does create some tax implications. But the Todd is, when you inherit the Todd, you inherit it at the value it is at the time of death. So if you sell it, then the transfer tax is just going to be on whatever difference that, whatever that works. It doesn't but if you had added somebody like a grandchild or something to your deed, and when they were in college or something, then maybe the property is worth $250,000. Now it's worth $450,000. Then that grandchild would have to, pay tax on that. So the Todd is valuable for that as well.
Yeah. So with the Todd, there's still what you're saying, the step-up basis, the way current law is, and that's for capital gains tax purposes. When the beneficiary who inherited the property through the Todd, sells, they would pay the realty transfer tax based on the full consideration, the full value of when they sell. So
after date of death and it transfers and there is a claim, except the beneficiary sold it, does the beneficiary have to pay the claim? Something about 8 months.
Yeah. So that's if there is the sale being done within 8 months of the date of death by the beneficiary under the Todd, I'd encourage them to talk with a lawyer, make sure they don't feel there's going to be potential there for claims and whether they need to do anything there or whether there needs to be some type of letter of indemnification or something involved or an escrow perhaps involved at that point with that transaction. Right.
Because when you inherit the Todd, you inherit the property with the mortgage, even a reverse mortgage, you inherit the HOA fees, you inherit taking care of the insurance, you inherit all the encumbrances with that property. And if there should be too many debts on that property, then it could go into probate.
If the Todd has 2 children listed jointly, is it split?
Yes.
50-50. Right.
They're tenants in common.
Which supersedes a Todd or a will if they're contrary to each other?
The Todd.
No matter when it was about the third time we've said this.
That's all right. People don't know when they're asking the question. It's a common question. It's a good question.
That's true. They might have asked the question prior.
That's right.
No matter if the Todd comes before the will or after, or whether the will comes before or after the Todd takes effect because the Todd is a deed.
Are you notified if someone creates a Todd without your knowledge?
No.
Not unless they maybe went through the process of your office for the notification system. So
right. Well, the law does not stipulate that the beneficiaries have to be told that they're beneficiaries.
Right.
I mean, and as Andy explained, if they want to disinterest themselves from, there's procedure to do that. It's already part of the law. It's not the Todd law, but the disclaimer. Yeah. So that's already, in the law. But I was going to go someplace with that, and then I got
That's all right. Next question.
excited.
Do you need to have an attorney to draft a Todd?
No, you do not have to have an attorney to draft the Todd. That is why the Uniform Law Commission invented the form, because they realized that there'd be people who would not have attorneys and but they were property owners. However, we always recommend that you use an attorney because, you can extract your own teeth and set your own broken leg as well, but it doesn't always work out that well. It's always good to have an attorney's experience and advice when settling matters that are so important as your property.
And I do know that all three of our recorder deeds offices in the state are aware of and being very careful to not provide legal advice to people. So the recorder deeds office is not going to draft the TOD itself. And so thank you.
If the deed has someone on it and there is also a TOD with someone different on it, who gets the property?
Sure that I quite understand the question, but so you're saying, let's suppose it's.
Oh, okay. If it's already I'm not sure what the question was, but I'll answer it a different way because we actually had this happen in our office. Somebody came in and wanted to do a TOD, and when we looked up the deed, his name wasn't on the deed. So that's a tangled title type situation or an heirs property situation, and we could not record it. We had to send them off to one of the 3 places where they can get low cost or free legal advice. And I checked with 2 of them, and the person never did show up. So it's very complicated to untangle a title. So
If the TOD recipient dies prior to the death of the owner and nothing is done to change it, does the will go into effect?
So if there's one beneficiary on the TOD and the beneficiary dies before the transferor on the TOD, then there's no beneficiary then to take under the TOD. So then it would go through the will or intestacy.
yes, the TOD is not a set and forget. Like a will, my husband and I made up wills before we went on Desert Storm. And, 20 years later, that will is still in effect. But with the TOD, because if my husband died, which he did, then this contingency can happen and that contingency. The TOD is not that way. TOD is a deed. It's not a will. So if you make a TOD and you don't have a will, if you make a TOD and you have one beneficiary and that beneficiary dies, remember I said the TOD is between living persons. If that beneficiary dies before the grantor dies, then the estate would probably just go by law. So it's not set and forget. You have to attend to it. You have to attend to it.
If anybody else has any questions, feel free to put them in the chat. I know I'm probably not going to get to a few of them here. We're kind of over time by about 10 minutes, but one more. How can people search for TODs? Is there a database?
Okay, if you just put in Kent County, Delaware TOD form, that will pop up the TOD form internal to I like you to enter it from the top with me in this outfit because I want you to read. I want people to be educated about it and inform themselves as much as a layperson can be informed by reading all the things I've curated to go on that database or on that website. But if you just want to look for the form itself, you can just search for that and it'll pop it right up. It's a fillable form. It allows for 2 beneficiaries and 2 grantors. However, if there are more beneficiaries or more grantors, you just add that extra page that's free. You have to have the notary sign beneath the additional page, though. So you can just add that page if you need more. The TOD is only meant for very easy cases. It's not really designed if you've got handicapped children or young children. I mean, there's just a lot of things where a will is just better. But for those people that can't afford a will and own property and would otherwise die without a will, like Abraham Lincoln and Prince and Michael Jackson and Aretha Franklin, and so many well-known people who had a lot of money and were well-known, but they died without a will, the TOD is the answer for those types of people. It's better to have a will. It's better still to have a trust. But if you're one of those people that doesn't have either of those and can't afford it, the TOD may be the answer because you get to leave it to who you want. You bypass probate. It takes effect immediately, and your heirs, your beneficiaries, have no say in what you do with that property during your natural life.
Good summary to end on right there.
Perfect. So I know at the start, I said, please send questions directly to me. If you sent them directly to Delaware Association of Realtors, all 8 of you, I didn't get to those, unfortunately, today. Please feel free to send us an email, info@delawarerealtor.com, and we'll try to get back to you as quickly as possible. Just want to thank both of you for coming and doing this presentation today. Appreciate how much we've worked together over the last few years. And I know your colleagues across the state also work really well with our members in both Sussex and in Newcastle. And if you have questions specifically about the process in those counties, reach out to those recorder of deeds independently. So with that, thank you all for joining us. Appreciate it. And you'll have this recording in your emails tomorrow. Have a good day.